Bismillahirrahmanirrahim. To proceed from where we left off, thanks to Shaykh Hamid. There were just two corrections I needed to make to what Muhammad had mentioned by way of introduction. The first thing is that the date for submission has been changed. It's not the 15th of March, it's now the 15th of May. We have 2 more months. The period for submissions that was given was a very brief period, very quick, and our work during that time that was taking place at an extremely frenetic pace. We were worried won't we be able to get in time. In any event, the extension has been granted, so hopefully there would be greater opportunity to contribute to the process. Just another remark, the second correction which I wish to make is that when we speak of support, we support the process, we don't support the bill in its presence, state. The bill is a document, it's a work in progress. It's a negotiated document. Government offers, we ask, they give some, they don't give some, we continue negotiating. So the bill is a fluid document. Therefore, we cannot quite support a fluid document. What we do support is the process of negotiation. There's another group that believes we shouldn't negotiate at all, we shouldn't engage at all. The view of the United Ulama Council is that we will engage in this process right up to the end until such time that the decision is to be taken, whether we go ahead or not, but we don't take that decision now, we will do that after the engagement. I proceed, however. What I will present to you, a number of points, 6 or 7 points. First of all, our political and legal situation in South Africa prior to 1994 and then post 1994. How much have things changed? Secondly, the idea of bringing in an interfacing Sharia with South African law. How compatible is it? Can it be done? Can it not be done? Do we need a Muslim Marriages Act or don't we need it? Thirdly, I will be looking at some of the advantages of enactment, advantages of having a law of this nature. We will enumerate some of them and discuss some examples of how Muslims stand to gain. Thereafter, we will look at the disadvantages, because there are certain disadvantages which both the proponents and the opponents of the process have identified. The opponents have identified them and they decided since these risks exist, we should disengage and reject. We have identified exactly the same kind of concerns, but we negotiate them in a different way. And I will explain how we intend to negotiate those particular challenges. Thereafter, we need to discuss the nature of the bill as a matter of choice and not as a matter of enforcement, which is extremely important. There happen to be a whole lot of unfounded assumptions. Many of those making these assumptions have not had the opportunity to study the bill or haven't made the time to study it. And even if they do make the time to study it, the bill is a document written in very dense legal language. It takes quite a bit of head breaking to understand. The MJC committee that sat down to study it had to consist of both ulama and lawyers to be able to penetrate to the understanding of what it is. So with those few headings, inshallah, at the end of that I will give you a rundown of the process up to now, starting from 1995 and saying where we have reached up to now. Thereafter, inshallah, we'll take questions, and after questions, there will be time, hopefully, for comments. I expect that inshallah will come somewhere in between. That's what happened in our previous 2 engagements. In any event, we proceed. Prior to 1994, the situations of Muslims in this country was what we remember it to be. Marriages were not recognized. As on account of the fact that marriages were not recognized, children were described as illegitimate. Why were marriages not recognized? Because the courts made a very clear statement. The law of this country made a very clear statement that Muslims are immoral people. They are immoral on account of the fact that they can marry more than one wife. Polygamy is immoral. Muslims who practice polygamy are immoral. It is called contra bonis mores, against good morals. And despite the fact that 95 to 99% of our people happen to be monogamous, de facto monogamous, despite that, they would say that you have one wife, you might have one wife for the rest of your life, but you always have the option of taking another wife. Therefore, your marriages are not recognized. You are immoral people. Your children, as a result of it, are going to be considered illegitimate. Back then, we did not really take offenses this, because when an illegitimate government calls you illegitimate, then it is a mark of honor. We carry that badge of honor and we say that when they call us illegitimate, it's merely a reflection of their own illegitimacy. But 94 came along And now the question arises in our minds, is there any need to bear the badge of yesterday still? Is there any need to bear the indignity of being called illegitimate or not having our marriages recognized? There are some who feel we would want to go on with the status quo. We do not need to register under any act. We do not need to bring any act into existence. Like we were living yesterday, we can continue living like that today. That's an option. I will discuss towards the end that we have something like 3 or 4 different options at the moment. But those who want to choose this option must recognize the right of others to take another option. In any event, post-94, there exists no need to be happy and to exalt and be called illegitimate any longer. The next point which I wish to discuss is leveraging of the existing judicial authorities. We have our own law, most certainly. In our law, we believe in it in our hearts. We practice it when we get up Fajr in the morning, when we abstain from khamr and khinzir, when we abstain from everything that is haram and we indulge in what is halal, when we buy and sell in a particular manner, when we shun riba and zina. In all of these matters, we obey Allah Ta'ala's law. Wherever we are, it doesn't matter whether we are in a minority situation, in a majority situation, or all on our own. Sharia will always apply to us because our Sharia is inscribed in our hearts and our obedience to Allah Ta'ala will always remain there. However, it does happen at times that Mr. A owes Mr. B a certain sum of money which he refuses to pay. Then you and I and every inveterate opponent of this particular process has no qualms of going to court and asking the judge to pass a judgment that this man owes me 20,000 rands, please force him to pay it. At this moment in time, the most inimical and hostile and inveterate opponent of this bill is taking the Jam'iyatul Ulama of Johannesburg to court on account of the registration of the name of that particular organization. They have no harm, they have no qualms in leveraging of the courts when it suits. But when it comes to this matter is nothing but leveraging of the judicial authority of the courts with a difference. When you leverage of the courts, when you take your rights to court to be enforced by the judge, it is just a coincidence that there happens to be an overlap between Sharia and the law of this country, and you take advantage of that particular overlap and say, let's enforce it. When you get hurt in an accident, when someone assaults you, when someone breaks into your house, you invoke the power of the law. All that we are doing here, we're invoking the power of the law to regulate our marriages. And which marriages? Not the one that is going to be enforced upon us by the courts, but the one that we are asking the government, the one that we have inscribed into this document here, the one that conforms to Sharia as far as we are concerned. We are asking the judges to take these laws and apply it to us, just as in the case of injury, just as in the case of robbery, we leverage of the courts. This document is merely an instrument to allow for the interface between Sharia and the law of the country to do what we have been doing in any event in all other aspects of our lives. What are the advantages? The first of those advantages is that through this process, our dignity becomes restored. Our dignity in terms of recognition, our dignity in terms of humanity, our dignity in terms of legitimacy. Now, as I said previously, if you don't want that, you don't have to take it. But if you don't want to take it, there definitely are others who refuse to be called illegitimate and who refuse to be unrecognized any longer. So that is the first major advantage to be regained. We will have our dignity reinstated. The second important part is enforceability. Every day, at the Muslim Judicial Council's Social Welfare Department, at the Majlis al-Shura, at the Muslim Assembly, at ISWA, at all of these organizations, Muslim women and at times men as well come to complain of the abuse and the trampling upon of their rights. Allah Ta'ala had given certain rights to the husband. Allah Ta'ala had given certain rights to the wife. وَلَهُنَّ مِثْلُ الَّذِي عَلَيْهِنَّ بِالْمَعْرُوفِ. Wives have rights just as husbands have rights. And a marriage is basically a contract in which there is a certain exchange of rights and duties between the parties. But it does happen, and all of us are aware, and many of us are guilty as well, of trampling upon the rights of the other. There's a man who doesn't pay the nafaqah of his wife on time. There's a man who marries a second wife and neglects either the first or the second family. These are not unknown in our community. They are phenomena which occur on a daily basis. So when they come to the MJC and to come and complain of it, the most that we can do is to tell the person, brother, what you are doing is wrong. First and foremost, if he does come. If he doesn't come, we have no way of sending out someone to force him to appear. to enforce the rights which Allah has already granted. We do not have that kind of power. In the same way as we do not have the power to cut off the hand of the thief, to lash the adulterer, and all of this kind. We don't have that power. So we are leveraging off the system where a person who refuses to carry out a haqq which Allah has granted, we're using the power of the courts to force him to do that in the same way as we use the power of the courts in civil matters and matters of proprietary nature. From dignity to enforceability, thereafter to the greater protection of rights. Since we can enforce, we are able to protect the rights of the weak. We are able to protect the rights of the disadvantaged to a greater extent than what we have been able to before. Greater enforcement of greater protection of rights leads us thereafter to something else. The greater protection against judicial activism. If a person seeks recognition of his marriage at this moment in time, as things stand now, there's only one way in which he can get it. If he seeks recognition of his marriage, he needs to go to court and he needs to marry under the Marriage Act of 1961. You go to court and you marry under the Marriages Act of 1961. All the consequences that flow from that act do not comply to Sharia. That man cannot marry another wife if he should now wish. That man, if his wife should take him to court, the judge will judge him by the standards of South African law and nothing else. I'll give you an example. 2 years ago, there was a famous court case, for those who have been following the Muslim person law scene, Hassan versus Jacobs. In the Hassan versus Jacobs case, a man had 2 wives. He passed away without a will. And the one wife took everything. The other wife went to court and says that I was also a wife. The judge says, yes. The constitutional court says, yes, you are also a wife, therefore you need to inherit from him as well. We say, wonderful. The second wife has been recognized by the court as a wife, that's wonderful. But now listen to the rest. You and I know that when wives inherit from the husband, how much are they, and they are children, they should get 1/8. And if there are 2 wives, they should get 1/16 each, and all the rest go to the other. That's under Sharia. The rest will go to the children. What the court did in this case, they say wife number 1 gets 50% of the entire estate, and wife number 2 gets 50%. Under which law? That's not Allah Ta'ala's law. That is in direct contravention of the Quran. That is in direct contravention of our Sharia. So if you choose that particular option, judges are going to judge as they see fit under South African law. The advantage that this particular act brings is that when a case is referred and the judge asks, under which law were you married? And you said, I was married under the Muslim Marriages Act, that judge will be, number 1, bound to judge by this particular act. Number 2, if something is not clear enough in this act and the judge needs to interpret it, he has to interpret it with reference not to Roman Dutch law, with reference not to English law, not even to customary law of South Africa. He has to judge it in light with Islamic law, which is our fiqh and our Sharia. These are all the assurances, the extra cover, the insurance which have been written into this bill to make sure that whichever judgment proceeds under this act will fall in line with Sharia. Which brings us to the other advantage.